Good afternoon. Welcome to the Heritage Foundation and our Douglas and Sarah Allison Auditorium. We, of course, welcome those who join us on all of these occasions on our heritage.org website. I would ask everyone here in-house if you'll be so kind to check that your cell phones have been turned off. That is always appreciated by our panelists and those recording the program. Of course, we will post the program within 24 hours on our Heritage homepage for your future reference. And we remind our internet viewers that they can send questions or comments to us at any time, simply emailing speaker@heritage.org. It's always a special pleasure to welcome a special guest to Heritage, and has the easiest introduction almost of anyone here at Heritage, our Ronald Reagan Distinguished Fellow Emeritus, Edwin Meese, who of course served as the 75th Attorney General of the United States. Please welcome him.
Thank you. Thank you, John, and thank you, ladies and gentlemen. It's good to be here today. We're looking at several things today. First, I think in opening our deliberations this morning, I think we all remember that this is the anniversary, of course, of 9/11, the attack on the United States. Some of us are old enough to remember Pearl Harbor. Very few that are here in this audience, but so we all remember 9/11, and I think in our own way we will not let this day go by without remembering both the attack on the United States, but more particularly the heroic actions of so many of our fellow citizens that day, and the fact that since that time I think all of us have been devoted to continuing to make sure that we're doing what we can to preserve the United States, to preserve the freedoms that we have. And today, while the battles are still continuing against those who literally are taking up arms against freedom throughout the world, that we continue to have them in our thoughts and in our prayers. In this proceedings today, we have two things that are new, or two beginnings, if you will. First of all, it's the launch, and I'll make a little more comment on this, the launch of the second edition of the Heritage Guide to the Constitution. But also, it is the first in our series of Preserve the Constitution gatherings that will take place over the course of the next 2 months. We started this just a couple of years ago as a way in which Heritage, and particularly the Center for Legal and Judicial Studies, pays attention to and talks about, and we hope provokes thinking about, the Constitution of the United States. William Gladstone, who was a former Prime Minister of England, once said that it was the most magnificent document ever drafted. And he was talking about this as a person who was the Prime Minister of a country that had an unwritten Constitution. Our Constitution, of course, was the first of its kind to be written, to have an actual contract between the citizens and their government, and particularly to have a document which limited the power of government. In most countries, you have a monarch, you have some sort of a principal person to whom its officers and its military swear their allegiance. Our officials in this country and our military swear allegiance to the Constitution. We say that when we say the Pledge of Allegiance to the flag. And so the Constitution has a particularly important part in the lives of all of our citizens, and that's why we felt that the necessity of reminding people, and particularly to seeking to have people have a greater understanding of what the Constitution is all about and what it actually provides. In the Heritage Guide to the Constitution, you find a most remarkable collection of scholarly work. Over 100 people have contributed to explaining what the Constitution says, what it means, how it has been interpreted over the years, and how it's important to people today. We have in the Guide to the Constitution the fact that it is now used by a number of our members of our Congress, a very hopeful sign that many of them boast of the fact that they have it on their desk as a frequent guide to their actions and what they do in representing the people in the legislative branch. I wish that the same fidelity of the Constitution carried forward into the executive branch, which on occasion we find perhaps the understanding that's contained in the Heritage Guide would be very helpful to increase the fidelity to that particular document. And as a matter of fact, it should be a useful document also to those in the third branch of government, the judicial system. But it's also useful to citizens themselves. And that's why the whole idea of having a heritage guide to the Constitution, because there have been a lot of books written about it. But I would suggest to you that there is one that is particularly good in terms of making it understandable and readily available to everyone in the country to use as a guide, to use as a means of understanding the basic foundation, the written foundation for the way in which our government should be operating. We have today as our speakers three people who are very much involved in the drafting of the Heritage Guide. I'm not going to list all of their accomplishments. In fact, I could use the whole hour just to tell you what they have done as legal scholars, as lawyers in practice of various sorts, and as historical scholars. They have a magnificent background. Let me say that if you want to find out more about that background, their biographies are in the Heritage Guide itself. But we have, to start off, David Forte, professor of law at the Cleveland Marshall College of Law. And David was the senior editor, who was the one who really did the coordinating work and put this together. We have Ron Rotunda, who has served on the editorial advisory board of the Heritage Guide, and who has holds the Henley Chair and is a distinguished professor of jurisprudence at Chapman University School of Law. And then we have Matthew Spaulding. Matt, of course, was a vice president for American Studies here at Heritage, is now the associate vice president and dean of educational programs at Hillsdale College. We hated to lose Matt when he left for this exalted position, but he didn't go far. He's, as you know, the Kirby Center is right across the street. But I mentioned Matt because this was really his idea, and he was the one that put together the plan, and with David and with the others, that made this really a possibility. It's been used widely. As I mentioned, the members of Congress and their staffs have it on their desks. In addition to that, so much has happened over the course of the last 10 years or so that we felt it necessary to have a new edition to bring it up to date so that it would be even more valuable to all of you who are likely to use it. And that's why today we will be launching this. Copies are available outside, as you probably saw when you came in, at a very nominal price. And we hope that it will continue to carry on what we at Heritage feel is very important, and that is the understanding and allegiance to the Constitution of the United States. And so with that, please join me in welcoming our first speaker, David Forte.
The first time we did this project, it took 2.5 years. And so when Matt called me and said, we need a revision, I said, no problem. That took 1.5 years of full-time work. So much has happened in the last 10 years. Mr. Meese, from the beginning, was the George Washington of our project. He was the one who inspired it, shepherded it through the heritage bureaucracy, kept it on track, and to him we owe everything that has resulted. Speaking of George Washington, there's a professor at Yale Law School, a brilliant man, Akhil Amar, iconoclastic fellow, and a few years ago he was suggesting to a Federalist Society audience a method of interpretation of the Constitution, and his method was, what would George Washington do? It's not a bad question. And in fact, the Heritage Guide asks a slightly larger version of that. What would the founders think? What would the founders think of a president who unilaterally changes the content of federal law? See the entry on the Take Care Clause by Sai Prakash. What would the founders think of a president who engages military forces abroad without needing to seek the formal approval of Congress? See the entry on Commander-in-Chief by John Yoo and Michael Ramsey. What would the founders think of a governmental agency that tells you what to do with your land because there may be surface moisture on it part of the year? See the note on administrative agencies by Michael Ullman. What would the founders think of a president who makes recess appointments while Congress is only in temporary adjournment? See the entry on recess appointments by Michael Carrier and Michael Rappaport. What would the founders think of a Congress that sends a president a bill containing thousands of new laws and regulations and spending authorizations that effectively prevents the president from exercising his constitutional power of veto? See the entry on the presentment clause. What would the founders think of a Supreme Court that supplants the state's police powers with the court's own views of what, for example, constitutes human life? See the entry on the Due Process Clause by James Ely. Perhaps more importantly, the question I want to address in these brief minutes is what would the framers think of what has happened to the separation of powers? That brilliant constitutional invention that was designed on the one hand to frustrate factions and passions, while on the other enabling cooperation for the common good, the result of which would be an effective government that still protects our liberties. As created by the framers, as explained by the Federalist Papers, and as practiced by the founding generation, the separation of powers had a number of elements, and so let's look at them. And we might be able to gauge just how well we have done with those elements that have been bequeathed to us by the founders. First element of the separation of powers, separate constituencies. The Constitution required that each element of government be peopled, chosen in a particular way in order to prevent a majority and a possibly tyrannical faction from gaining power. The people chose the House of Representatives. The states chose the Senate. A separately constituted college of electors chose the president. And the president and Senate chose and approved a specially trained group of people to be the judiciary. Moreover, the double security of our freedoms, as James Madison put it, was to limit the range of power of the federal government as a whole, leaving the enormous residue to the states. Well, the 17th Amendment removed the states from choosing senators. The College of Electors remains, but presidential elections have become more of a popularity contest, and even appointments to the courts are now tinged with political objectives. Second element, partial agency, as explained by James Madison in Federalist 47. In that idea, or construction, one branch of government is given a key role, a part agency, in the operations of another branch. The president's veto is part of the legislative process. Through the necessary and proper clause, Congress sets and regulates much of what happens in the executive and judicial branches. The Senate must approve principal executive appointments, as well as treaties. The president nominates members of the judiciary. But for partial agency to work, something more must happen. The branches must be willing to deal with one another, to be agencies in one another. It doesn't help if the president is not an agent in the functioning of the legislative branch, if he simply is absent. It doesn't help if the House or Senate don't speak to one another. So I'm not sure that this method of partial agency is the current method of governance in Washington at the present time. A third element were political checks. The process of changing members of Congress or of the Senate or of the President who may exceed their powers. But what kind of political check do we have on the EPA or the IRS? When I first wrote this, I wrote IRA, which must have been a Freudian slip. What kind of political checks do we have on the EPA or the IRS or the host of independent agencies seemingly accountable to no one? Fourth, the moral sense of self-restraint. This is a significant element in the separation of powers. Checking won't do everything. That's what Marshall understood in Marbury versus Madison when he eschewed any attempt of the judiciary to involve itself in the political discretionary work of the executive branch, when he interpreted Article 3 to allow Congress the widest range of regulating the appellate jurisdiction of the Supreme Court. This principled manner of acting as a self-restrained Republican leader, as exemplified by George Washington, or even the restraint in Congress when it could limit the appellate jurisdiction of the Supreme Court, but chose not to do so under the argument that it might disable the courts from performing their separation of powers function. When you think of standing requirements, cases have to have standing and ripeness and not be moot. These are self-restrained elements that a government imposes upon itself. I'm going to return to this right at the end. Two more elements. Fifth, the Constitution does allow for extraordinary actions when there is a crisis of some element exceeding his allotted power. And that's impeachment and the amendment process. Now, both were intended to be very limited, and both have been very limited, and they are designed to be used only in the most extreme kind of situation. So we can leave those as they are, I think. Sixth, and not many people think about this, non-compliance. There are times when one branch so invades the core functioning of another branch that that other branch will simply say, we will not obey. And that other branch is right. Let me give you some examples. Right after the Civil War, Congress attempted to determine the outcome of a particular case that was before the Supreme Court through a legislation. The case is called United States versus Klein. And the Supreme Court said, you cannot, Congress, under your allotted powers, prescribe a rule of decision of the court. Reaching a decision is what the courts do. A more recent case, the Supreme Court held that Congress could not reopen a case that had already been decided by legislation. Non-compliance. That's what the law said. We're not doing it. The War Powers Resolution. Every president, from President Nixon to the present, has said that the War Powers Resolution constrains the essential commander-in-chief power of the president. Non-compliance. They will not follow. This leads to the question of unilateral presidential actions. The unilateral presidential actions may be justified non-compliance, or it may exceed constitutional limits. Let's take a look at that. So, what are the powers of the president over acts of another branch that he regards as unconstitutional? After all, he takes an oath to support and defend the Constitution. Well, his primary one is to veto unconstitutional acts. The Constitution gives that to him directly. In fact, George Washington didn't believe that his veto extended beyond unconstitutional acts. He couldn't veto unpopular acts or acts he thought were of bad policy. But because it's hard to draw the line between a veto of an unconstitutional act and an act of bad policy, we have acceded as practice, and I think appropriately, that the veto of political acts that the president regards as imprudent is perfectly proper. And thirdly, what I just explained, noncompliance with intrusive acts that takes away from the essential powers, maybe the pardon power of the president, is appropriate for the president. There are many signing statements of President Bush and President Obama that are exactly this way and are perfectly constitutionally appropriate. But what about non-compliance with acts after the law has been passed that the president thinks are unconstitutional? There the line is not so clearly on the president's side. And certainly I should think it's not on the president's side when he decides not to comply with acts that he thinks are bad policy under the faithful execution of the laws clause. And lastly, what we've seen lately, unilateral actions outside of statutory or treaty authorization, where he wants to have an agreement with the United Nations so he can avoid the treaty requirements of having the Senate approve it, or that was penultimately, and lastly, the actual changing of the text of a law. And thus we come back to the essential element that I had left to discuss in my conclusion here. The sense of moral self-restraint as essential to the proper separation of powers mechanism of our country. This is what the founders called public virtue. Why do we see so little of it today? Professor Philip Munoz of Notre Dame has given us a clue. As we all know, in 1938, the Supreme Court left the business of checking Congress. No longer would it enforce the limits of the commerce power upon Congress, no longer the spending power. And to a large extent, the Supreme Court has also left off limiting the president. What has the Supreme Court done since then? Well, it said, our job is to protect rights. And what's been the result? It has left Congress under no sense of constraint. And so Congress now can regulate under the commerce and spending powers, believing it has no limit to what it could regulate, and regulate it has. The Supreme Court, as the exclusive guardian of rights, thought no one could limit an idea of what a right was, and it went into the business of creating new rights that had been completely beyond the ken of the founding generation. And the president, already given discretionary power by the framers in order to check what they had feared would be a more powerful legislature, now moves in the farthest limit and beyond what the executive power is. So what the result has been when the Supreme Court left the field of checking, of being faithful to the commands of the Constitution, is that the branches no longer feel an obligation to check one another, and by not doing so are tempted to leave off the greatest element of the separation of powers, that of their own moral self-restraint. Thus, what is needed most, I suggest, in this country, to return to the original vision and experience of the founders, is a renewed sense among our public leaders, among the politicians whom we elect, of public virtue and respect of the individual rights of the people and the limits to what government is entitled to do. Thank you.
Please welcome Ron Rotunda. Ron?
And thank you very much. I have to, we're supposed to have a power.
It will appear.
Oh, it's over there, okay. I see, I have to sit here so I can see what I'm doing. This is, I'm to the left here. The Hugo Black said one of the most effective ways
Wait a
of.
minute, Ron, it's not up yet.
It's on the side.
Okay.
It's on the side?
Yeah.
Okay.
It's the devil's invention,
can watch
like the telephone, the computer. All right? Hugo Black said one of the most effective ways of losing our rights or diluting them is for the justices to substitute for the words of the Constitution some other words and go around interpreting that. When judges interpret statutes, they routinely look at the legislative history to help decide its meaning. Now, granted, the history may not be clear. I mean, Pharaoh's dreams were not clear, but Joseph could still interpret them. The history at least places some parameters on judges. What Justice Black believed of the Constitution and is also true. That is, our organic law, looking at the founders' history, at least places some parameters. When you have catchphrases like having a heart as well as a head or nourishing a living Constitution, They're just empty slogans. What the judges are telling us is that rather than look inside the Constitution, they're going to look in themselves. And once they look outside the Constitution, they're just imposing their own views. Some examples. There's his language, a little delayed there. All right. We start off with flag burning. All right. There's two ways to dispose of a flag. One is out of respect, and one is out of disrespect. That is, flag etiquette says that you're supposed to burn the flag when it's tattered and worn. And flag protesting etiquette says you burn the flag when you want to desecrate it. Well, the Supreme Court, with Scalia in the majority, 5-4, said that's free speech. What you're really punishing is not the act of burning, it's what you think while you're burning it, and free speech has to protect that. Justice Stevens said, well, the flag's unique, and we can't have unnecessary desecration. I think that's a hoot. Like, you can have a black mass, but you use one virgin, not two. We can have desecration, but unnecessary desecration. And then Larry Tribe, another person who looks outside the Constitution and into himself, says, there's no right to desecrate the flag. That's not what the First Amendment says. Kelo v. United States. This is Scalia again in the majority. The drug agents search inside the house using thermal imaging to discover the high-intensity lamps for indoor marijuana cultivation. The Ninth Circuit on the left coast, where I'm from now, says, well, that's okay, because when you're doing something inside the house, you don't have any expectation of privacy. That was a new one on me. And Stevens in dissent says, in my judgment, that's okay. Now, all the potheads think that Stevens is the great liberal, but he would have taken away our rights that had been more like him. Come on. Oh, here, okay, Kelo v. New London. All right. For the IT people, can you hear me? Because we have sound with this. Well, we don't. Okay. But I did it with sound. And the background.
Make some sound.
Yeah, well, I'm not going to make this one, but I'll tell you about it. The background sound is a toilet flushing. Because Stevens for the court says, and it's what I think of as logic. This is what passes for logic in the Supreme Court. The city of New London can use its taking of powers under the Fifth Amendment applied to the states through the 14th to take over private property and give it to another private citizen. He said, so what does it mean when it says, nor shall private property be taken for public use without just compensation? Stevens says it means, nor shall private property be taken for public or private use without just compensation. I have my house, you'd like it, you've got more influence in the legislature than I have, and so the legislature just take my property. I don't want to sell, sorry, you got to sell. All the dissenters, the ones the press bemoans as the conservatives, they're taking away our rights, says, O'Connor just said it right. That is, any property can be taken. And who are the people that are going to be the beneficiaries? The ones with more political pull, the large corporations, the development firms. Because we need constitutional rights to protect the little guy. The big guys don't need protection, and they're not going to get it from this or that Supreme Court. As for the victims, she says, they're the ones that at the wrong end of the stick. The founders could not have intended this perverse result, which is true enough. 13 years later, the land is generating no tax revenue. It lies vacant. It is fallow. The developers abandon the property because when the government picks winners and losers, it tends to pick losers. And so that's just, if I'm gambling with somebody else's money, I don't care as much as when I gamble with my own, which is why I don't gamble. All right, Brown v. Entertainment Merchants Association. Law said you can't sell or rent violent video games to minors. California could show no link between watching the video games and doing anything bad, or at least the same link as when you're watching Bug Bunny cartoons and Roadrunner. And sadly, our great literature, the Odyssey, the Iliad, they're very violent. TV news, talk about that as being violent. I can't watch it anymore. And the court said we shouldn't be adding a list of speeches that are just unprotected by the First Amendment. They'd said earlier obscenity, a constitutionally defined term which is fairly narrow, that's unprotected. But you just can't add terms. Breyer said it's just a modest restriction on expression. Breyer goes home from a case never feeling bad because he always writes what he thinks is the right thing. Scalia told me when he voted with the majority in the flag burning case, he felt bad, that is, he didn't want to burn the flag. But he said, that's when I knew I was a good judge, when I do something that's against my instinct, but I find it in the Constitution. District of Columbia v. Heller. Okay, we got to do it. All right. Scalia for the court says that a law that says you can't possess any gun violates, under no circumstances, violates the Second Amendment. The Second Amendment has an inherent right of self-defense. So what does Stevens say? What the Second Amendment really means, just look at it, is the collective action of individuals having a duty to serve in the militia. That is, the Second Amendment is not a right of the people, it's the right of the state to force me to fight in the militia. Now, it's not a very long amendment. I suggest that you read it and tell me how you can interpret that language and say it's a duty to serve in the militia. And if you could do that, you can be on the U.S. Supreme Court. Breyer, by the way, joined the Stevens dissent, and he says it protects an individual right. Apparently not reading the Stevens dissent, which he signed, because they said it was a collective right. But he said, even though it protects an individual right, the court should defer to the legislative judgment if it's reasonable. Well, very seldom does the legislature, they do once in a while, very seldom they're completely unreasonable, that they're irrational like the wild beast. But he says it's a very important amendment. We have a protection, and you can't take it away unless the legislature decides to take it away. U.S. v. Lopez, this made it a federal offense to carry an unloaded gun in a suitcase on the sidewalk in front of your house if the sidewalk's within 3 city blocks of a school, even if it's a Sunday school and it's not Sunday, or it's a summer recess and school's not there. And the court said, violence in schools is a terrible thing. There's all kinds of ways the government could prohibit it. In fact, the state could prohibit guns in schools, and Texas did in that case. But holding a gun, just holding something, is not a commercial act. It's not even economic activity. And the Commerce Clause says you need a commercial act. Breyer says the court should defer to Congress because the law banning possession is rational. Contrast Hugo Black. Justice Black said whether the activity is commerce or not is ultimately a judicial decision. Breyer says, no, it's a legislative decision. Congress can do whatever it wants. Harry Truman, in 1947, he vetoed a law, passed over his veto. The law banned independent corporate and union-related campaign expenditures, not contributions, expenditures. He said this is a dangerous intrusion on free speech. Vetoed the law passed over his veto. Now we have a few cases. U.S. v. CIO, United States versus CIO. The Union Weekly endorsed a congressional candidate. That is, it has a right to have a newspaper. It published an endorsement. The court says that we're going to interpret the law very narrowly because we have the gravest doubts about its constitutionality. Rutledge, Black, Douglas, and Murphy, they concurred in the result, they got to the merits, and they said that deprives voters and speakers, whether individual or a group, of free speech. U.S. v. Automobile Workers, 1957. The majority said that the union television broadcast that endorsed a candidate is covered by the statute and is sent it back for the trial. The jury's acquitted. We never went back to the Supreme Court. But Black, Douglas, and Warren, 3 of these right-wing extremists, they said any ban on independent expenditures is unconstitutional. They said deeming any political group too powerful isn't a justification for withholding First Amendment rights to any group, labor or corporate. These were the lions of constitutional jurisprudence, and they all agreed with this. Now flash forward to the present day, McCutcheon v. FEC, and the majority says Congress can't limit campaign expenditures because they don't want people to talk too much. You're allowed to have a megaphone, but not a big one. And Breyer in the dissent says, wait a second, now the First Amendment, we got to balance these rights. There's the rights not just of the individuals, but the rights of collective speech. What's collective speech? That's government speech. So it turns out that the First Amendment, like the Second Amendment says that's your obligation to serve in the military, the First Amendment says that the government's got a right of free speech. Why? Because it's kind of powerless, and we have to make sure that the court protects it if the legislature decides to limit the collective speech of the government. For 200 years, the courts used the intent of the framers to protect their rights, and justices like Black, Douglas Warren, Robert Scalia, Thomas Alito, Kennedy. Now we're told that Congress can do what it wants if it's reasonable for the court to think that the legislature is reasonable. It's kind of rational 2 steps removed. And at this point, the sound effects would have shown applause. And
But I figure.
okay, thank you.
Okay, Matt Spaulding.
I have no explosions. It's hard to top that. Thank you, Mr. Meese. Thank you to the Heritage Foundation. This is actually a very important occasion, not only to look ahead to the anniversary of the Constitution next week, but the publication of this volume. The first one was in 2005, so we are just under 10 years since that one came out. It's quite an amazing thing. I have to agree with David's comments. Ed Meese, who I had the lifetime privilege of working for, saw the possibilities of this book and this project from the very beginning, as did Phil Trueluck, I would add. And they saw the possibilities. There was this great scholar out there named David Forte, great scholar and great teacher, who also had this idea, in addition to other scholars like Ron Rotunda, who we got to work with. And I was merely young enough and naive enough to think we could actually do it. And lo, those many years, we accomplished the fact. I think it's a project that is going to be hard, if ever, to be replicated. We had this idea from the beginning that we would go clause by clause by clause. We would not skip a one. And as David will recall, it was hard sometimes finding a scholar to write on some of those obscure clauses. But 10 years later, we have produced another volume. I'm very proud to be associated and with these great scholars, and to be associated with Heritage still as a Salvatore Fellow. That is named after the great entrepreneur who, with his wealth, gave that money to institutions like Heritage to advance the principles of the founders. Much has happened in the last 10 years, which leads me to think that we need a new originalism, or to say, at the very least, a return to originalism. But I'll come back to that. We've debated the Constitution from the very beginning, indeed, before the Constitution itself. The American Revolution, in many ways, is a debate and an effort of constitutional reform. How do we take what we've learned from British constitutionalism, the rule of law, and bring it to America in written form? Madison once wrote there were two compacts to the American founding. One was the Declaration of Independence, asserting the ends of American government, equal rights, the consent of the governed for the sake of life, liberty, and the pursuit of happiness. The other was the Constitution, that act of law-giving which orders our politics, secures our rights, defines our nation, that constitutes us, creates the institutions and political arrangements by which we express our consent and govern ourselves. From the moment the Constitution was written, and during its writing, we debated it. One need merely look to the debates of the Federalists and the Anti-Federalists. The first histories of the American founding, John Marshall's, David Ramsey's, Mercy Otis Warren's, talk about the period of the Constitution, but they had a problem. Madison's notes weren't available to them, so they skip over that. Joseph Story's three-volume commentaries on the Constitution, which we use in many cases as our guide from 1833, talks about the text of the Constitution, but very little about the Convention. This changed with the publication of Madison's notes in 1840. George Bancroft's Great History of the United States looks at them extensively, opening up more debate about what exactly was intended. The first group to use those notes and take advantage of it were the abolitionists, who use it to criticize the Constitution. Jump forward, that is, passing over the debate over slavery, which was, of course, central to understanding the Constitution, in an argument which I would suggest that was resolved when Lincoln properly recalled the nation to the Founders' Constitution. This all changed after the Civil War, when the progressives set out to create a movement to redefine what the constitutional republic meant. This revolt against formalism had various forms: theology, history, law, politics, social policy. Scholars like James Allen Smith, most famously Charles Beard, argued that the Constitution represented the triumph of moneyed elites, protecting their economic interests. Progressive historians assert that the democratic forces of the American Revolution, having produced an idealistic declaration, were later defeated by reactionary forces that produced an anti-democratic constitution. The Constitution's focus on controlling and restricting government power, moderating democratic opinion, was viewed as misguided, a serious barrier to extensive government necessary for progress. The results? The Constitution must be made flexible, pliable, living. And it turns out the judiciary would play a key role in all of this. Oliver Wendell Holmes famously argued that the life of the law is nothing more than experience, a key factor in the development and interpretation of the law based on the consideration of the felt needs of the time. In this view, the outcome-oriented jurisprudence, later called legal realism, judging is not distinct from legislating, but merely a different form of it, filling the gaps, so to speak, created by general laws. Judges determine not only what the Constitution says, but certain questions about also, in effect, what policies will best harmonize with the document's presumptions. The response to the claims of the progressives came in several forms. The scholars, historians like Robert Brown and Forrest McDonald, argued against the economic interpretation. Mainstream academics attempted to forge an alternative historical consensus, emphasizing Lockean principles of classical liberalism, a Republican sense of Whig ideology. Over time, these historical scholarly debates turned attention increasingly to a reconsideration of the founders' ideas and political thought. You see it in the essays of Douglas Adair, Martin Diamond, the rival of the Federalist Papers. Meanwhile, constitutional historians and practitioners argued against the progressives. Scholars at the time, contemporary scholars, Edwin Corwin, Andrew McLaughlin, defended traditional constitutionalism as a means to order and restrain government. You think of jurists like William Howard Taft and George Sutherland, the National Association of Constitutional Government, publications like the Constitutional Review. And then there were political figures. In many ways, I would argue that the modern conservative movement begins with the Republican Convention of 1912, when several important figures, in particular Henry Cabot Lodge and Elihu Root, took the stand in the name of the Constitution against Theodore Roosevelt. They were followed by others, perhaps most famously and most articulately Calvin Coolidge. The progressive view came to maturity in the New Deal. I need not go into the details of that. The response to the New Deal and the response to the later Warren Court led eventually to the revival of traditional constitutionalism of the founding, or as Attorney General Meese in his important speeches in 85 and 86 called, a jurisprudence of original intention. The thrust of recovering constitutionalism against the progressives, that thrust was very successful. He made it nationally prominent, this debate. He changed how the Senate thought about these questions and how the public looked at the courts. Led to great research, education of judges, some of whom still sit on the Supreme Court. Likewise, scholarship continued along its way, recovering the thought and action of the American founding. The works of Adair and Diamond continue in the works of various students of political philosophy, the Claremont School, now followed by many scholars at Hillsdale College. But the weakest point of this broad sense of originalism, and my point today, is that the weakness is in our politics. The New Deal weakened that part, destroyed the base, if you will, of constitutional originalism in the political field. Conservatism in its early days looked to many places for its sources of authority. Traditionalists looked to Burke, other European thinkers. They weren't that American, if you will, largely because they were convinced that progressive scholars were right about the Constitution. At the same time, there's a rising interest in economic analysis, warning about a new road to serfdom. All very good, but not that constitutional or political for that matter. Neither fully embraced the American founding. The fusion of conservatism was more a result of the Cold War. More recent popular turn of conservatism back to the founders can be traced to Ronald Reagan, again contributed greatly by Mr. Meese. But it's this aspect of the originalist movement I think we need to do more work. I am struck by reading Mr. Meese's speeches again. Indeed, I was looking at them last night on all places, the Justice Department website, which has what I can find to be the best collection of all those speeches. I was struck by looking at them how much he emphasized structure and form, the distinction between the Constitution, as he says, and constitutional law. It's about coordinate branch construction. The Supreme Court was not the only interpreter. Each branch had a duty to interpret as it performed its functions. But unfortunately, originalism, in the popular sense of shaping politics, has come to be associated with the courts. And it's less consistently and rigorously been applied to other departments, especially from the point of view of those departments. I think it is now time we need an equivalent scholarship of that aspect of originalism and argument, and more work needs to be done. If there's anything we see in the pages of this great book, it's a clear divide growing over time between the founders' constitutionalism and the living constitution given to us by the progressives. Although shaped by the courts, the regime created by the progressives, the very concept of it is political and comprehensive. It's a new administrative order, a bureaucratic order, a new form of governing that threatens to overwhelm us, threatens self-government, threatens to take away our consent. The courts can't restore the Constitution by themselves, partially a question of institutional capacity, but also the natural arguments of judicial restraint, but also politics, and especially constitutional politics, the ones that bring in popular opinion, needed to reconstruct constitutional government. The rise of the Tea Party has been, I think, one of the most important aspects of recent political history, especially since the publication of our first edition. That's our opportunity. The progressive project, it seems, has not yet been settled. It's up for debate. And here they are, all these Americans turning back to the Declaration and the Constitution. Their instincts are good. They talk less about rights in the Bill of Rights and more about structure. They want to talk about federalism, checks on power, all to the good. But it needs to grow more, to mature and deepen. I don't think we have sufficiently articulated, because we haven't focused on it sufficiently, the constitutional arguments needed right now in politics. I fear sometimes we are overly technical and legalistic, judicial, if you will. We object to what the president's doing. Well, we can make a good technical argument about whether we should do this or not. Let's sue him. That doesn't strike me as a good constitutional, political argument of how the House of Representatives should deal with the president by going to a third branch to ask for permission. There's an important distinction between what Jim Caesar calls legalistic constitutionalism, rules to decide cases, definitive answers enforced by courts, and political constitutionalism, what I could call constitutional politics, that emphasizes political actors making political decisions in the political realm in light of the Constitution. We need both. They both must work together, but they are different. We need a new fusionism in the conservative movement between judicial originalism, scholarly originalism, if you will, and political originalism. Each has a contribution, but they are unique in what they do. They're important legal questions, but the most important issues in our politics right now require prudence. That is, political prudence, not just jurisprudence. Legal constitution is necessary but insufficient for the task, I think. What would this look like? Very briefly, it would emphasize distinctions of principle, say between constitutional government and the rule of bureaucrats. Equal rights for all, special privileges for none. Talk about the purposes of government. It would emphasize the constitutional role of individual branches, the separation of powers, as David talked about, federalism, checks on power, an aspect of constitutional interpretation. If the judiciary does not have the sole claim on interpretation, the final say, as Mr. Meese likes to say, the legislative and the executive also interpret the Constitution through what was called construction. We need to think more about constitutional construction, more scholarship on that, more writing about it, the application of meaning in particular circumstances. We need more legislative, more about moves and steps, pathways. How do you amend something in a way that makes it more constitutional, recognizing that it still has a constitutional problem? How do you deal with things like entitlements? How do you drive a wedge between the administrative state, which we really object to, and other things we could possibly accommodate? The legislative branch doesn't have to follow the precedents of the courts. They have to build consensus, move political opinions, create governing coalitions. And the legislature and the executive, the popular branches, can rally the people, as Reagan did, which gave rise to originalism, modern originalism in the first place. These decisions are less definitive, often temporary, less technical, partial, decidedly less than definitive, but politics looks for results over the long term. They're directional, and that's how you reform the lines of the debate. In the end, an original confined to the courtroom, it seems to me, necessary and important, but insufficient for the task of constitutional revival. We need something more dynamic about checks and balances, robust federalism, political figures making the case and arguing, deliberating, perhaps even making compromises to preserve the Constitution. That's the Madisonian solution, I would argue. The work to be done defending recovering the Constitution is to be done by statesmen in the end, in the realm of politics, not ordinary policy, in ordinary policy and issues that go beyond what the courts can do. But it strikes me that this is actually the originalism, Mises' originalism, consistent with the original intention of the argument. And it's time to pursue that, to pursue originalism's larger project, which this book and all of our work contributes to. Thank you.
Well, thank you to all three of our speakers. They've certainly given us a great deal of food for thought. We have just a few moments to entertain questions. We'll start right over here. Please wait till you get the microphone, state your name, and then ask the question.
Good afternoon. I'm Sam Wright, retired Navy JAG, and I run the Service Members Law Center. In the House, but not in the Senate, a member introducing a bill is required to include a statement explaining where in the Constitution is the authority of Congress to enact this kind of law. Is that a useful reminder of these principles, or is it a useless formality?
Both. That's the problem. I was here during that debate. I helped write it. I'm a strong advocate of it. It's a great educational tool. The problem is we try to turn it into actually a mechanism to force an outcome. It becomes a substitute for real debate. As a result, now it's just completely ignored. That's what I mean by, I think we sometimes think about these things wrong. We assume the same logic that applies to the courtroom, if you will, applies to politics as well. And it just doesn't. And so we oftentimes lose a lot of those cases, a lot of those arguments.
Ron, you want to comment?
Yeah, I think it's helpful. I mean, it doesn't cause any harm, and it's a useful thing. I think we still laugh at Nancy Pelosi's statement when she said, "Is it constitutional?" But of course, you know. And what does it mean?
It's not a serious question.
Yeah, it's not a serious question because everything's constitutional, and we had 5 members of the court said it wasn't commerce. That is, an omission, not doing something, is not commerce. It may affect commerce. Everything does. Our breathing does. Plus, of course, the global warming from exhaling, which is why I've stopped that a long time ago. But so it's useful, but it's not. It's just the first step on a long journey.
David?
Matt, I'm not as familiar with the text of that law. I presume that the law...
It's a House rule.
House rule, that's correct. The member of Congress simply stands and says, this law is constitutional based on the Commerce Clause, vel non. That's it?
Right.
Well, why don't you write the rule to say, tell him why? I mean, the person must say, under what clause does this bill proceed and why? And at least we begin to get them thinking as you want them to begin thinking in constitutional terms.
But further evidence, the Constitution does not give mechanistic answers to a legislator. They have to argue and deliberate amongst themselves. That's what we need to. That's what we need to get to.
The why question.
Yeah, the why. Right.
Yeah, okay.
Next question. Right back there, yeah.
Hi, my name is Paul Bartow, and I work at the American Enterprise Institute. I have a question for Mr. Forte. You mentioned in your remarks that in 1938, the Supreme Court stopped checking the Congress. I was just wondering what sparked that and why they stopped.
I'm doing you don't want to hear my answer. I'm doing a lot of research. There's a great debate about the switch in time, whether Justice Roberts switched and so forth. My research, now we're getting technical, I'll just give you that. My research indicates that the switch did not occur fundamentally till Justice Black took his seat. That even NLRB versus Jones and Laughlin was still a continuation of the same principles up until then, but that Justice Black, in his private correspondence with Chief Justice Stone, intentionally changed the basis of the reasoning, and that's why we went over to no longer checking Congress. But that's really a technical issue right now.
You wouldn't say in the vernacular they chickened out.
No, Mr. Meese, I don't think they did. I think Justice Black, don't forget, was the floor manager of the court packing plan, and so he went into the court with a political agenda to change the nature of the court. It wasn't that he chickened out. He had the votes by then. The progressives had won. The personality of the persona of the court in the governance of the country changed from one in which it was concerned about the structural integrity of the Constitution to another in which it was merely an observer of the conflict of factions in the legislature, approving whichever faction came out. In other words, its notion of how a republic worked was quite different, the 1938 court from the court beforehand.
Down here?
Anna Smith-Lacey from the Hungarian Embassy. What would the founders think about a Supreme Court that more and more often references international law in its jurisprudence? And what would the founders think of an American political culture that references democracy much more often than Republican self-government or the limits of a central government?
Ron, you start on this.
Yeah, well, I mean, first, we had a revolution because we didn't like what they were doing over there. I mean, we didn't like to be governed by British law. And I think it's fine, I suppose, to talk about it as a free country, but the notion that because several dozen countries think they should chop off your hand when you commit a crime or are a thief should not illuminate whether or not we think it is cruel and unusual. And I agree with Chief Justice Roberts when he says there's so much out there, you just simply look at a crowd and you pick the ones of your friends and say you've got authority. So I think it is bad for the court to do that. And I'm not sure that it affects some of the justices. They just know how they want to get there, and they can't find any other authority except to go someplace else. And maybe that should tell them that they should be concerned about what they're doing. The second part of your question was what the...
Why are we more Democratic than Republican?
Well, the federal income tax is changed our society dramatically because by giving various deductions and subsidies, they can insinuate themselves into every aspect of our lives. And to some extent, it is inconsistent with the federal government. That is, the federal government becomes all powerful because of the income tax. I think that two things that would change our society dramatically would be term limits and flat taxes. That is, if you had flat taxes, the government can still go around giving money to its friends. That seems to be one of its jobs, is to take money from Peter and give it to Paul, but they'd have to do it by check. You know, here's a check, and the newspaper can take a picture of it, and we kind of wonder why Solyndra should be getting $500 million or $1 billion. But now it's all done in a very underhanded way, where it's just so complicated we don't know about it. And it's the same thing for term limits. The typical dispute is not between Republicans and Democrats, it's between incumbents and voters. All the campaign financing, it is a First Amendment violation, but the reason we have all this campaign finance regulation is to protect incumbents. So we have all these things really have an effect of our lives in ways that we didn't, when we thought of the federal income tax, we don't think of controlling every aspect. The federal income tax code of 1913 was the size of this piece of paper. I have seen the entire code engraved on a bar of chocolate this big. Now, it's changed. It's changed since then.
David.
Thank you. I'm glad you asked that question about what the founders thought, because it's actually a more complex issue. All the founders who were trained in the law in the 18th century were trained in the law of nature and nations. It was together. It was the jus gentium as well as natural law in the fundamental sense. So John Marshall had no trouble thinking about general principles that were observed in a kind of Grotian way by nations around the world. That is different from the way foreign law is being referenced today. Foreign law is being referenced as what we call in America law office history. It's being used as a make-weight for an argument that members of the court want to reach in a certain way. It is not referenced to generic principles of natural law which are represented by nations' observations in a Grotian way. So the founders would have approved, and John Marshall did, a general reference to internationally observed natural law principles. They would not have approved to the positive law pick and choosing that the current Supreme Court uses in looking at European courts, for example.
Can I make just a very quick comment
Matt?
on the democracy point? The reason the American founders were critical in many ways of democracy because they had second thoughts and concerns about human nature, right? Man was driven by his passions as well as his virtues. The government had to account for that nature because it couldn't change it. So we had to create forms that checked, filter democracy. Right? We created a republic. The great assumption of the modern left, progressivism, modern liberalism, is that no, indeed, man is not bound by his nature. It can be changed. It can be reformed. It can be made different. So faction, the problems of human passions, is no longer a concern. Right? So when that's the case, let's let democracy abound. It's a fundamental disagreement about human nature, which I think is really the heart of the matter.
Actually, I'd add something to that. That is, the economists tell us, talk about the wisdom of crowds, that a group as a whole is more likely to make a better decision than any one individual. In fact, if you, was it Who Wants to Be a Millionaire? The statistics show that when you ask the studio audience, they're right about 90% of the time, and when they call in a guest expert, it's like 60% of the time. And that's the fundamental postulate of democracy. People as a whole will know what to do, but we want to protect minority rights, because plebiscites, for example, are typically tools of dictatorships, not democracies. So the framers built into the Constitution various institutional protections, the indirect vote for the president, the two houses of Congress elected differently, and so on, and in the hope that things would move slowly. You know, God protect us from an efficient government. And a lot of the modern Democrats forget about these individual right aspects. They know what should be done. The rest of us are more modest, as I'm smart enough to know I'm not that smart, and so I'd like to persuade others. And if I can't persuade them, well, maybe I'm wrong, but I'll have a chance to persuade them later on. The Health Care Act, the Affordable Care Act, Obamacare, is a nice example of this. They had absolute majorities in the House, Senate, and the President. They just rammed it through. The President said there was an election, they have consequences, we don't have to worry about you. And as the result, we have something with lots of problems, so the President just decides to rewrite it. And you will see periodically, I think it was the governor of one of the southern states said, oh, I wish we could just suspend the Constitution for a while so the President can just do what he wants. And one of the typical, Bono, I think, said something very similar. You know, that the nice thing about Cuba is they can do what they want. They have the best healthcare system. That's why all the Americans are trying to go to Cuba for healthcare. Wait a second. Well, anyway, and the framers understood that give people time to debate, and on the whole, we will come out right over time, which is why we're at the top of the food chain in terms of countries. People want to come here. Nobody wants to escape from North Korea to South. They want to go from North to South. The North wants to come to the South, not the South wants to come to the North. The East Germany wanted to go to the West and not vice versa. Democracies, what we call liberal democracy, not in a liberal, conservative, democratic, republican sense, but in the sense of protecting democracy with liberties, that's what all these countries want. Since 1970, the number of real democracies, I'm not talking about Russia, some real democracies where parties change, or there's no demonstration in the streets, and no violent taking over by the military. They've gone from less than 30% to 60%. And someday they'll be all democracies, and then we will be much more safe and prosperous. But until we have liberal democracy, until we replicate here, what in other places, we're just going to have a lot of problem. But we've discovered it, and we have our mistakes. But overall, it's as Churchill said, better than any other form of government.
Well, ladies and gentlemen, we have overstayed actually the length of time we normally gather for, but let me just say that I think that our speakers have given us a lot to think about and certainly should have provoked a great interest in the Constitution. So if you're interested, copies are available at a nominal price outside, but join me now in thanking our speakers for a great showing. And we're adjourned.